Hey everyone, it's Rob Ryder. Monday, I believe it's July 30th, 31st, 30th, 2012. I set up a talk show site here. Haven't done it yet. I don't know the first thing about running one, but a lot of the questions I get asked, I can't type the answer. It just takes too long. And while your question may take a minute to ask me, it may take me 15 minutes to answer it. So I'm going to try it a different way. I'm not going to have scheduled calls like a Thursday call or not like that. I'm just going to decide I'm going to do a call and send out an email saying I'm doing a call, and if you want to join, you're welcome to. Sorry, that's really the best I can do. So to do that, this is the TalkShoe ID, 122402. And if you email me at quarterrecord@aol.com and just put in there, add you to the email list in the subject line, then you'll be added, and whenever I send something out, you'll get it, number one. If you want to get in on a call, excellent. But this is the kind of stuff we're going to be talking about right now, and taking clues from ancient books. And one of my favorites is Blackstone's Commentaries on the Laws of England and Wales. This is out of Book 3, Chapter 4 of the Public Courts of Common Law and Equity. And for those who are new to this, haven't heard this before, right? Blackstone's Commentaries, along with many other books, old books, his is like the newest, and they get older, are considered books of authority, and if you bring them into court and use them as the evidence, it's the law. So if you understand what they say, you'll understand the law. And so from these, this is what drives me in the direction I'm going. And those that don't understand, I'm just going to try to show you where it's coming from. If you don't care, that doesn't matter to me either. But everything I do, I've researched, and I have a reason I'm doing it. So in this book, we are next to consider the several species and distinctions of courts of justice, which are acknowledged and used in this kingdom. And these are either such as are public and general jurisdiction throughout the whole realm. So they have general jurisdiction. They have it throughout the whole realm. Or such that are only private and special jurisdiction in some particular parts of it. So either everywhere or just little pieces. Of the former, there are four sorts: the universally established courts of common law and equity, the ecclesiastic courts, the courts military, and the courts maritime. And the first of such public courts are courts of common law and equity. So common law and equity is one kind of court. Then there's ecclesiastic courts. That's what they got apparently down there in the bishop's headquarters. You got the courts military and the courts maritime. Those four courts exist. But, as Blackstone always does, he starts with the best for you, and we're going to talk about the courts of common law and equity. So the policy of our ancient constitution, as regulated and established by the great Alfred, was to bring justice home to every man's front door by constituting as many courts of judicature as there are manors and townships. Every township will have a court in the kingdom, wherein injuries were redressed in an easy and expeditious manner by the suffrage of neighbors and friends. So they were the jury. These little courts, however, communicated with other of larger jurisdiction, and those with others of still greater power, ascending gradually from the lowest to the supreme courts, which were respectively constituted to correct the errors of the inferior ones, and to determine such causes as reasons of their weight and difficulty demanded a more solemn discussion. So, even though it was in the township, it was connected to the Supreme Court. These are the courts of justice. And it starts in the township and goes all the way up to the Supreme Court. And they're always justices. So this isn't a state court. This isn't a federal court. This is a justice court. The course of justice flowing in large streams from the king as the fountain to his superior courts of record, being then subdivided into smaller channels till the whole and every part of the kingdom was plentifully watered and refreshed. an institution that seems highly agreeable to the dictates of natural reason as well as more enlightened policy, being equally similar to that which prevailed in Mexico and Peru before they were discovered by the Spaniards, and which was established in the Jewish Republic by Moses. So, breaking away from Blackstone, so in the Michigan Constitution, 1963, it says, the judicial power of the state is vested in one court of justice. And we're talking courts of justice. Where to say it? To bring justice home to every man's door. And one court of justice, which shall be divided into one Supreme Court, one Court of Appeals, one trial court of general jurisdiction, known as the Circuit Court, one probate court, and courts of limited jurisdiction that the legislature may establish by 2/3 vote of members elected. Okay. It says there's one circuit court. One trial court of general jurisdiction, known as the Circuit Court. It says there's one of them. Well, when you go to any county in Michigan and you walk up to the court building and big bold letters, all caps, some number, Circuit Court. 80th Circuit Court, 23rd Circuit Court, 19th Circuit Court. Well, those must not be the circuit courts they're talking about because there's only one. So, what they mean by a circuit court in here is when Michigan was first discovered, became a territory, the president sent a governor and 3 judges. And they split the state into 3 districts. It had one county, it was the county of Wayne. Had one city, the city of Detroit. And they broke the state into 3 districts. Each district is where one of the judges sat, and he wrote a circuit within the district. Later on, they added 4. So then they had a governor and 4 judges. And then they became a state. So they left the territory with a governor and 4 judges, 4 justices of the peace in the territory. Now, as they subdivided the territory, every time they subdivided it, they put another governor and 4 justices in that section. And as they went smaller and smaller and smaller. So in your township, you have somebody who's playing the governor, and you have 4 justices of the peace. And in fact, until 1963, during the entire time Michigan was a state, they always elected 4 justices of the peace for every township. Well, then they quit doing that in 1963, and people say, well, they don't have them anymore. Well, sure they do. They just went back to the way it was in the territory, and they appoint them. And as we go through here, I'll show there's many appointed people that are actually the power players as far as I'm concerned. The elected people are just, they're window dressing. They're for the democracy. I want the people who are watching the republic. And they're the ones who are trying to keep us from. So, in Mexico, each town, province had its proper judges who heard and decided cases or causes, except when the point of litigation was too intricate for their determination and it was remitted to the Supreme Court of the Empire. So, it stayed in the town. If the town couldn't handle it, it went to the Supreme Court. That's really what you have, right? You have a direct line to the Supreme Court through the territorial side of the courts. Separate from the states, because a city has nothing to do with the state. It was remitted to the Supreme Court of the Empire, established in the capital, and consisting of 12 judges. Peru, according to Vega, a historian descended from ancient Incas, was divided into small districts containing 10 families, all registered under one magistrate who had authority to decide little differences and punish petty crimes. 5 of those composed a higher class. 2 of these last composed called 100. 10 hundreds constituted 1,000, right? So boom, boom, boom. It's all the same court, just as you go up in stature, the justices of the peace have a different commission over a wider area based on their experience. So the guys down in your township, they're only justices of the peace within the jurisdiction of the township. Otherwise, the municipality. In like manner, we read Moses that finding the sole administration of justice too heavy, chose able men out of Israel, such as feared God, men of truth, hating covetousness, and made them heads over the people, rulers of thousands, rulers of hundreds, rulers of fifties, rulers of tens, and they judged the people at all seasons. The hard causes they brought unto Moses, but every smaller matter they judged themselves. So you're going to see that a municipal court has as much power as a Supreme Court. These inferior courts, at least the name and form of them, still continue in our legal constitution. But as superior courts of record have in practice obtained a concurrent original jurisdiction with these, so whatever the small court does, the Supreme Court has concurrent original jurisdiction. It's like it could be in either court at the same time. And as there is besides a power of removing plaints or actions thither from all inferior jurisdictions, so you can also bring all other actions back to this court. Upon these accounts, among others, it has happened that these petty tribunals have fallen into decay. Well, hell yeah, no fucking lawyer wants you to know you can take him into city court and kick his ass. But that's what Blackstone is telling you. Because you know what? That attorney, he don't have a license to practice law in the city. He doesn't have a franchise. He doesn't have a license to practice law in the city. He broke the law by bringing the case. And in the municipality, in the territory, it's contempt of court to sue in the name of a fictitious plaintiff. And we could be putting these things on a complaint, having a justice of the peace be our witness to our complaint, give it to the city attorney and have him deal with it. And so, fallen into decay and almost into oblivion, we hardly even know it exists. We think it's just traffic court. But the same guy that sits on these traffic cases sits on murder cases, at least in New York. They got the dude doing traffic cases sitting on murder cases. I wonder how good of a judge he really is. If they put him on a capital case, whether for better or worse, may be a matter of some speculation. Yeah, it ain't been better for us. When we consider on one hand the increase of expense and delay, and on the other the more upright and impartial decision that follow from this change of jurisdiction. So if you keep it in the civil courts, you have increased expense and delay. We know they drag shit out. If you bring it back to the city court, you have an upright and impartial decision that follow from this change of jurisdiction. So by you changing the jurisdiction, because both Blackstone and Koch say that a man can choose the court he answers into. It doesn't matter that some state court is sending you some paperwork for some case. You can go answer it in your municipality. That's where you're supposed to. That's the nation you belong to. If you've been paying your municipal taxes, which apparently we haven't been, it could be a good place to be. But this just to me shows that Blackstone is saying, I don't know how much clearer he can make it, right? Was to bring justice home to every man's front door by constituting as many courts of judicature as there were manors and townships. Every township has got this court that's tied directly to the Supreme Court. So, municipal domicile, sometimes used in contradistinction to national domicile and quasi-national domicile to refer to residents in a county, township, or municipality. Okay, so you can have residents in a county, township, or municipality. And that's also called a domestic domicile. Now look that isn't for you. Right? You're an immortal living soul. You're domiciled in the earthen vessel. But you need to have a domicile by law for your earthen vessel and your landed estate, what they call a body corporate, so you can discharge the functions of your office. Okay? And as you'll see, according to the Michigan statutes, if you're inhabited, domiciled in the county, that's your municipality, your land, your body, and landed estate is the property of the county. You're their property. And here's why. This is right out of the Michigan statutes, 45.3. Michigan compiled laws, MCL, 45.3. County body corporate purposes. Each organized county shall be a body politic and corporate for the following purposes. That is to say, to sue and be sued, to purchase and hold real property and estates for the use of the county, to borrow money for the purpose of erecting and repairing county buildings and for the building of bridges, yada, yada, yada. Well, what is county property? MCL 45.4, Section 4. All real and personal estate heretofore conveyed by any form of conveyance to the inhabitants of any county or to the county treasurer or to the governor of the late territory of Michigan or to any committee, trustee, or other persons for the use and benefit of the county shall be deemed to be the property of such county. And all such conveyances shall have the same force and effect as if they had been made to the inhabitants of such counties by their respective corporate names. All your real and personal property, if you're an inhabitant of the county, gets thrown in as county property. It's their property. A body politic is a metaphor in which a nation, you're the frickin' nation, small n nation, is considered to be a corporate entity. We don't want to be considered a corporate entity, so we don't want to have a body politic. We need to reject the body politic. This is what happens in the township. Because here you're king. Inhabitants of organized townships as body corporate, powers and duties. So here it's only a body corporate. Didn't say anything about a body politic. The inhabitants of an organized township are a body corporate. Okay, what you are, as far as the township is concerned, is you're an elector. If you're 21 years of age, been in the township for more than 30 days, you are a qualified elector. However, if you haven't paid your municipal taxes, which are the only taxes you're really responsible for, well, then you're a delinquent peer. You've broken a law. You got a crime against you. Okay, so all inhabitants of an organized township are a body corporate and have, in addition to other powers that are conferred, all the following powers and duties: to sue and be sued and appoint necessary agents and attorneys for that purpose. You get to appoint agents and attorneys to sue and be sued for you. Because if there's something going wrong, it's their fault. They're supposed to be running your business. So you're going to appoint an attorney, not hire one, right? The township attorney, the city attorney, whoever it is, when you put in a complaint, he becomes your attorney. All right? So we're not going to put in court cases. We're just going to go put in complaints about court cases, about people not having a license to be a peddler in the city. And a township board may investigate any matters under the jurisdiction of the township. So anything within the township is within the jurisdiction of the township. Okay, and the supervisor may serve upon persons subpoenas by a court of proper jurisdiction in the county in which this township is situated. They can examine people under oath, produce a document, right? They can hold court in a township hall as easy as they can down at the courthouse. Except this one is all under oath. And that's why you want to bring your business, if you want to call it that, to this court, the court of your domicile. It's the only court you can be sued in unless you consent to leave the jurisdiction. So what they do is they go to your county and they get a writ of no determinable value, less than $20, for you trespassing on their property, and they get a stamp. They get a stamp of a justice of the peace. And then he takes and he transfers it to another justice of the peace. Says so right in the statutes. That's what they do. Well, you have 14 days to answer that. Right? Because we heard one guy's side of the story. What's yours? Well, you could not go to where the complaint's coming from, but go back to your domicile, because man has a right to answer into whatever court he pleases. So you'll go to the court that protects you under common law and just simply say, well, It's contempt of court to sue in the name of a fictitious plaintiff. Therefore, this case is unlawful. The plaintiff must appear in proper person and provide evidence under penalty of perjury to substantiate his claim. Or he's using color of law against me, a living man, and that's fraud. In the case of a foreclosure, the lender has failed to execute the contract. Therefore, he's in breach of contract. And you can't sue in the name of a fictitious plaintiff, and the plaintiff has appeared provided evidence under penalty of perjury. These are the only things you got to point out. You don't need to talk about the case. Just point out the defects in the law. Have a justice of the peace be your witness on your complaint and take it over to the county attorney. And make sure that it gets recorded. Right? I don't know what's going to happen next, but let's try that first, see what happens. Okay. So we could read all this stuff. It's just saying that, all this stuff is happening, man. It can happen at the county as easy as any place else. This is a court of general jurisdiction. And then the supervisor of each township shall be the agent for his or her township for the transaction of legal business, by whom a suit may be brought and defended, and upon whom process against the township may be served. So you become part of the body corporate of the township, or your inhabitant does, your landed estate, but you're being defended by the superintendent and the attorney. And the only thing that can enter their jurisdiction is common law. If somebody is going to come in and swear to it with an affidavit under penalty of perjury, well, then they can't take you to court. You're not in their jurisdiction. You're in the jurisdiction of the territory. Under public international law, the law of nations. So what is a body corporate? It's called the owner's corporation. Well, exactly. You're the owner of a body corporate. And it deals with either physical property issues or issues relating to people living together. Yeah. Either to do with your property or somebody bringing a charge against you. Can we all just get along? So you're not the body corporate. You have a body corporate. It's your property. It's your all capital letter name landed estate. It's your property, and any account that's under the all capital letter name landed estate is your property. Okay, and you need to make sure that any municipal liens are satisfied and recorded in the office of the recorder of that municipality. Otherwise, there is a lien against your real and personal property. And they don't need to tell you about this and that you owe the tax. And it's up to you to make sure the records in the office of the recorder are correct. Because whatever is in the office of the recorder is the law. And I believe it's the city clerk. I told some people this interesting thing. I looked at my certificate of live birth, and the guy that's down there as a local registrar, his name was John H. Gates, I think it is. When I Googled his name, he was the city clerk of Bay City. And that was the birth county I was born in. I guess that's his other hat. Municipal lien. A lien or claim existing in favor of a municipal corporation against property owner for his proportionate share of the public improvement made by the municipality whereby his property is specially and individually benefited. So they can impose a tax for running a string of lights down the road. And if you don't pay your share of that, because those lights do help your general area, right? Well, if you don't pay your share of that, and it was done on a special assessment and you didn't even know it, well, they can put a lien against your estate. So in Alpena, you can do this. It shall be the duty of the treasurer upon request made by any party to issue his certificate showing all unpaid taxes, special assessments, and other charges which are a lien upon any specified property. So Rory, Rich, Tom, you were asking me earlier what to do. Well, this tells you what to do. It shall be the duty of the treasurer upon request made by any party to issue his certificate showing all unpaid taxes, special assessments, and other charges which are a lien upon any specified property. Go see the city treasurer. But who is this recorder? Well, they are a judicial officer in England and Wales, and apparently here in America. It now refers to two quite different appointments. The ancient recordership of England and Wales now form part of a system of honorary recorderships. Well, guess what? They have an honorarium, your honor, which are filled with the most senior full-time circuit judges. So, right, the recorder is the most senior full-time circuit judge. A modern system statutory recorder, on the other hand, appointed barristers and solicitors to part-time positions as judges who sat 3 to 6 weeks a year with powers of a circuit judges. So in old times they were these, and now we've added to them, we have these other judges, part-timers. But they're still recorders. Formerly, a recorder was a certain magistrate or judge having criminal and civil jurisdiction. So anytime they say formally, they means in due form of law. Recorder was a certain magistrate or judge having criminal and civil jurisdiction in a city or borough. A recorder was originally an appointed person with legal knowledge by the mayor or alderman to record the proceedings of their courts and customs of such city. Such recordings were regarded as the highest evidence of fact. So whatever is in the office of the recorder having to do with you is the highest evidence of fact, highest form of evidence. And so if the discharge of mortgage to your land has never been recorded with this office, then it looks like there's a lien against the land, even though it's been long since set off. Okay, and we read this one already. This just says, about the powers there. And okay, so this had to do with, well, who does what, right? So in the first township meeting, they're going to take an oath by Section 1, Article 9. And so this is for all officers, legislative, executive, judicial. This is the oath they're going to take. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of this office according to the best of my ability. You know what? If they haven't taken that exact oath, then they haven't taken the only oath that counts, because this is the one set out by the Constitution. No other oath, affirmation, or any religious test shall be required as a qualification for any office or public trust. All right, so if they're not doing it with these words, I don't think they've taken a lawful oath. And then at the township meeting, moderator shall administer an oath to the other inspectors, and then the other inspectors who haven't been so qualified will administer like oath to the monitor. So everybody can give each other an oath. It sounds like they're all judges to me. And they could have those powers ex officio. For instance, the mayor of a city is a conservator of the peace, and he's a justice of the peace, and it's ex officio, simply because he holds the office. That's one of the powers that comes with it. But now here's the interesting stuff. The supervisor of each township is the chief assessor. If the supervisor is not certified at the proper level, the township board shall provide an appointment of a properly certified assessor. The supervisor of each township is the chief assessor. So whoever the chief assessor is the supervisor. So if the guy who got hired or who got elected isn't certified to be an assessor, then he has a disability and he's not the supervisor. The appointed guy is. The guy behind the curtain. And he shall be this supervisor, the chief assessor, shall be the secretary of the Board of Review. So as it said earlier, when you're an inhabitant with a body corporate in the township, you get to appoint the supervisor to be your agent. Well, excellent. I want the guy that's the chief assessor to be my agent. Okay, the supervisor may appoint township deputy, who shall serve at the pleasure of the supervisor. the deputy shall take an oath of office and file the oath with township clerk. Okay? The supervisor of the township may place person under oath. To me, that makes him a judge. Each township clerk limited with the time limit for filing the oath of office before entering the duties. Okay, basically, they're going to have a deputy. The deputy shall have an oath. So, all these oaths for these township deputies are supposed to be on file with the clerk of the township. So it's one of the things I asked for today on Freedom of Information Act. Not only the elected officers, but the appointed officers. All these deputies are appointed. The treasurer shall appoint a deputy. Well, he's got one too, and that deputy will put their oath with the clerk. So the clerk will have the oaths. And then we'll find out who's really running the show. And then I really like this one. Constables shall execute with sufficient sureties to be approved by a township board an instrument in writing in which the constable and his or her sureties jointly and severally agree to pay each person who may be entitled to money that the constable becomes liable to pay on account of neglect or default of the constable in the service or return process that may be delivered to him or his or her service. In other words, if you weren't properly served, this dude's at fault, this constable, because he's the one who's supposed to serve the summonses within the municipality. And so it's built in that he's got to have this bond to cover that. Now, they may not say in Alpena, it says that a city police can be appointed as a deputy sheriff. So you see all these deputy sheriff cars running around thinking they're with the sheriff department. They're not. They could be a constable from the township. It's the same as a city, or they could be a city policeman driving around in a car that looks like a sheriff's car. Okay, so that was that one. Now, what else did I have? Okay. Real quick. Hey, let's go to this one here first. Well, hopefully. Just real quick on this, it's Form 632, page 5. This is a form that I found on the Department of Treasury website for Michigan under local government. And when I saw what it said in the notice, this form is issued under authority of the general property tax. Filing is mandatory. Failure to file may result in imprisonment for a period not less than 30 days. No more than 6 months. A fine not less than, all right? If you don't file this, you can go to jail. Well, hell, what is it? Pray tell. What it is a personal property statement. And on this form, so this is a Form Michigan Department of Treasury, Form 632. You can go Google it and find it yourself. And as you notice, it's from, so the assessor is sending this to the name of the taxpayer. So to your all caps. Now, it's funny, in Michigan, when I get stuff from the tax authority, it comes with my last name first, a comma, first and second. That's how it is on my certified copy of record of birth that I got at the age of 5. Looks like a little deed that came in a manila envelope that had the place for the name, and all I had on there for the name was my first and middle, Robert Allen. Going back to the story of Steve, who last summer took some paperwork to the Jesuit president of a Jesuit college and said, hey, we sent this stuff to the Pope. He didn't pay any attention to it, and the Jesuit looked at it, and he signed it and sealed it, put it in an envelope, wrote Steve's first and middle name on the front cover, handed it to Steve. Steve said, where's the last name? Jesuit said, that is your name. Good enough for me. So this is supposed to come to you yearly. This form is supposed to be filled out yearly, and it has a bunch of questions that would be asked. And, it's like, well, shit, I'm supposed to be filling this out. It makes it sound like it's supposed to be filling it out. But wait, what does it say down here? The undersigned certifies that he or she is the owner, officer, or the duly authorized agent for the above named taxpayer. Cheapers, if you're in the county, they act like your property's theirs, so they must be the duly authorized agent. They must be filling this out. Full and true statement of tangible personal property owned and held by the taxpayer at the location listed above. Okay, so this form lists all the personal property. Right? And of course, it's your typical tax form, right? You got to go all over the place for shit. So let's just go down here. For instance, Section A, including fixtures and furniture. The prior number goes here, and then every year from 97 to 2011 gets a number, and it gets an assessed value. And this is supposed to have been sent to you every year. And it says right here, within the city or township, that was taxpayer. Okay. Down lower, we'll find out this is supposed to be filed in the township. But these are just the different forms of personal property they're talking about. Okay, so on and on and on. Well, I've never seen this before. I certainly never filled one out. They put me in jail because I had a warrant for my arrest for $25 I owed on child support, but they never put me, no one's ever bothered me for this, so I have to think somebody's putting it in. Because you can go to jail for not doing it. And it says in these instructions, where does it say? Here we go. You are advised to make a copy of the completed statements for your records. This form must be filed with the city or township where the personal property is located on December 31st, 2011. Do not file this form with the State Tax Commission unless you have specifically instructed to do so by the commission staff. So this form, maybe it was supposed to have been mailed to you and, they forgot, but they certainly need to file it in the city or township where the personal property is located. City or township. Didn't say county. City or township. The county may be filling this out because right now you're a body corporate body politic and you want to reject that body politic, go to the body corporate as a inhabitant of the township. So I took a copy of this with my Freedom of Information Act and asked for my copy, that this should be filed in the township. So one of the things I asked for in the Freedom of Information Act. But anywho, that's that form. And then just real quick, this is on mortgages. Okay, look it. Let's just read this real quick. The identity of the landowner may vary in this act depending on the context. For example, suppose that the bank holds a mortgage on Blackacre, a parcel of real property owned by Hines. Hines is going to be the grantor. Hines wants to sell this property. The bank has a mortgage on it. Hines has entered into a contract to sell to Bailey. Bailey's going to be the grantee. On the warranty deed, he'll be the grantee. For the purpose of obtaining a payoff statement with respect to the balance of the mortgage obligation, Hines, the grantor, is the landowner within the meaning of this act, even though Hines, the grantor, seeks the payoff statement in anticipation of sale of the real property to Bailey. So until Hines signs the paperwork over, he's the landowner, and the landowner, as the landowner, he was supposed to go to the bank and get a payoff statement to make sure that his mortgage is paid off, because on a warranty deed, he's conveying this to Bailey, the grantee, free of all liens and encumbrances. So, however, by contrast, assume that Hines now has performed the contract of sale by deeding the real property to Bailey, the grantee. So the warranty deed is really a contract of sale. And Hines did not go and get the payoff statement the way he was supposed to, but now he's done the contract, and you, or Bailey, the grantee, right, are now the landowner. So Hines is going to go ahead and do his thing. So now if the bank fails to record a timely satisfaction of its mortgage, right? If the bank fails to put the satisfaction of mortgage in for Hines, as required by this act, Bailey, the guy who now is the landowner, is now the landowner for the purpose of giving notification to the bank of its failure or for the purpose of recovering damages on account of the bank's failure. You, as the grantee on your warranty deed that you got, when you bought the property from another dude, you're the grantee. You're now the landowner. The bank was supposed to put the grantor, Hines, whoever you bought the property, to put a copy of the satisfaction of mortgage in the land record. And that has not been found to be done yet. And so if it isn't done, they have a specific way to do this. And this is in the Uniform Residential Mortgage Satisfaction Act. Universal Uniform Residential Mortgage Satisfaction Act. And in there, so it says now if you're Bailey and you're the landowner, right, you got the warranty deed in your name as the grantee, you need to notify the bank, and you notify the bank through their agent, who's your satisfying agent, who in this act can only be one or two people, either the title insurance company or a licensed attorney. The only two people that can act as a satisfying agent or satisfaction agent to contact the bank, and when they do, the bank has 30 days to produce the satisfaction of mortgage and have it recorded in the public land record, or the title company will write an affidavit of satisfaction of mortgage and say we contacted the bank, gave them 30 days. By law, they've had their opportunity to contest this. They didn't contest it. Boom. They put it in, and now it's satisfied. So, doubtful that it's ever been recorded. And I'm not talking about your satisfaction. You need to look at your warranty deed and see who you bought it from and say, hey, bank, when I bought this, within 60 days of me getting this property from Hines, you were supposed to put Hines's satisfaction of mortgage in the land record. Has it been done yet? And you do that through the agent, and you need to do it with proper notice, which means, some kind of receipt mail. It tells in the manual what you need to have. And that's how you get the ball rolling and get the 30 days going. If it doesn't happen, you can go file a complaint under the seal of a justice of the peace of your municipality to the city attorney, who will act as your attorney general and go prosecute the case for you. Now, I know a lot of people think that sounds like pie in the sky, but I'm just saying that's what these things say, and we're going to go give them a try. So, and this is just other stuff off of that. Okay, so listen, I'm done with this. I just wanted to point a few things out. Here shortly, I'm going to schedule a call of some kind, or I'll send an email out, and I'm going to do a call. But if you're not on my email list, it's courtofrecord@aol.com. Just say in the subject line, add the email. And maybe we can go through some of these concepts. Instead of me just talking, I really need to hear what it is you don't understand so I can focus on that. And who knows what you'll bring to the table by going and asking a question. So, you all have a good night. See ya.